Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England.
Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England. Ben is the founder of FDAImports.com and a former FDA regulatory counsel who helps companies worldwide navigate the complex intersection of the FDA oversight and international trade. I'm Leanne Lyon, and today we're breaking down a major issue for importers, the Supreme Court challenge involving tariffs under IEEPA, and what companies can do now to protect themselves, including potential refund strategies, depending on how the court rules. Thanks for being here today, Ben. These are exciting times. There are a lot of Supreme Court rulings that are coming out, and one of them really has a lot to do with, well, what you do. Do you want to lean into that?
Yeah, certainly, Leanne. Thanks so much for taking the time today. So the Supreme Court has heard arguments already on the legality of tariffs that the president had imposed last year under IEEPA. That's the International Emergency Economic Powers Act, and it's called IEEPA in the trade. And IEEPA is, as it sounds, an international emergency economic powers act. And so ordinarily it's conceived of, you have an army at the door, an army at the gates. And so the government needs to exercise emergency powers in order to pull together, either control the ports or to gather additional resources, like through tariffs, for instance, or to restrict what's allowed to come in and out for security reasons. It might be that there's a need to increase some particular industries in order to boost production of armor and armaments, right? That's the kind of things that happen when you're looking at a war. Well, the president declared emergencies related to the fentanyl crisis, right? The fact that we have so much fentanyl that's been crossing the border coming into the country. Also, the gangs and cartels in South and Central America primarily, that have been trafficking in drugs, right? I'm in the FDA space, so I use the word pharmaceutical. But these are not pharmaceuticals, right? These are illicit narcotics and drugs, guns, people, right? All of the things that you hear about. And so President Trump declared an emergency related to that, an international emergency, and consequently imposed tariffs on lots of different countries for lots of different reasons under those authorities. That's what's been challenged it's actually been challenged in the lower courts, starting in the Court of International Trade, and has made its way up now to the Supreme Court that's already heard arguments, and we're waiting for the ruling. We are now January the 15th, and the ruling, if it's not tomorrow, it'll be probably next Wednesday-ish. So we're pretty close to it. So that's where we are. And my clients, of course, are importers and exporters. And many of them have paid hundreds and thousands and millions of dollars of additional tariffs because of IEEPA. So if it falls, right, if President Trump's arguments fail, then the expectation would be that the tariffs and duties were not legally collected and would need to be refunded. And then you hear in the news arguments about what that would do to the government if the government had to return those funds. That's a completely different argument. But I really wanted to sort of lean in today mostly. We can talk about, if I've paid the tariffs, how do I get my money back? And so that's sort of like what I wanted to talk about, because some of that has to do with what do you do before the ruling, and then what do you do after the ruling.
So the ruling hasn't happened yet. It may come soon. It may come before or after people are actually watching this show. What would you want those businesses, those entities to know whether or not the ruling has come out yet, in terms of preparing for either scenario?
Yep. So the expectation would be that it would be in the news all over the place. Folks in the industry probably would find out because their customs brokers would tell them, or they would have seen it on the nightly news, because it's been a big battle. It's been a huge political question. And what the Supreme Court does is being watched. I think the issue is, if the ruling comes out and I'm just now seeing the video, what do I do now? Well, let's first assume the ruling hasn't come out, and you're watching it. There's a couple of things. there's arguments that have been made that, in my opinion, is that it makes the most sense for importers to do what's called file a protest with customs about the duties that they were forced to pay under IEEPA. This is not the traditional duties that you would ordinarily pay when you import goods. This is the extra money. And so there's a process for filing a protest with customs about being required to make those payments. You can protest a customs entry for 180 days after liquidation. And so for those in the industry, liquidation is when the government has sort of like closed the books on the entry. They've looked at all the data. You've given them, as an importer or the customs broker for the importer has given all the information about what it was, what the duty rates were, the origin, whether there are any free trade agreements and any duty treatment that's special. And it gets to a point where the law closes the books to settle claims. Basically, it's like after a certain date, you can't really claim anything about that entry. However, for another 180 days, the importer can protest the action, like what the final outcome was. And it's during that period when the protest has to be filed. Our recommendation is to file a protest. File the protest because in some cases, the courts have gone the direction that if you haven't filed a protest, it doesn't matter what the outcome is in the court. It won't apply to you because if it's protestable, you have to protest first. Okay. So here, there's a legal question as to whether this is even protestable. But I don't want to get into that. All I'm going to say is that it's not that complicated to file a protest, and you can do it you can protest about many entries at the same time because they're going to be very similar entries a lot of times. It's the same products coming in repeatedly. So one is file a protest. Then the next question is, do you have to file a lawsuit? And these are called Me Too lawsuits, where you sort of like you just borrow the arguments of the original complaint and go in and you make it apply to your case as the facts apply. And our recommendation is, yeah, you probably ought to do that too. And the reason you ought to do that is that if you have a case already on file in the Court of International Trade, and then the ruling comes down, you're going to get bundled in with the ruling on the case, right? And so it's going to make, to the extent refunds apply, you're going to probably get the money back more quickly because your horse is already in the race, right? You've already got a horse out there and it's running in the race and it's trying to get to the finish line, and the Supreme Court ruling is the finish line. Now, so that's what if I'm listening to this and the Supreme Court hasn't ruled yet, those are the things I would do. Customs brokers can file a protest for you. You can file a protest for you. Attorneys like me and law firms I work with file a protest for people. They're not that complicated. There could be voluminous. There could be a lot of them because some of our clients have literally thousands of entries that are at stake. And each of these entries then have duty. So we're talking about hundreds of thousands and millions of dollars of duty. So you do want to, I would recommend doing that, filing the protest and filing the CIT case. And a lot of law firms are doing it on a contingency basis. That's how I've seen it done most of the time, where they just basically take a piece if they win. The law firm does, and they don't require too much on the front end. If you lose, then you don't pay them anything extra. You paid whatever you paid on the front end. Now let's stop and sort of shift gears. What if I'm now coming across this video and I'm saying, oh, I wish I knew this last week, right? Before the Supreme Court ruled, and the Supreme Court has now ruled. The answer is your position is only different in terms of it's primarily only different in terms of timing. To the extent that you have a protestable case, you would protest to customs, and I would say protest to customs. You have to do it within the 180 days. That's a rule no matter what. You're not going to break that rule. You have to do it during the 180 days after liquidation. And then file the lawsuit. The problem there is going to be you're not going to get to like bundle in with the group that already is in the system at the time that the case was ruled on. And that means now you're trying to like get in with them, right? and that's going to take longer. And it could take a couple of years longer. Like it could take you a couple of years more time to get your money back, to the extent that you're going to get money back. So that's why you kind of want to act before the case, because you have a better chance of getting results more quickly if the court rules in favor of the plaintiffs and against the government. Uh, so those are. I know I gave you a lot, but I
Yeah.
but I kind of wanted to get the beat out there quickly, because someone may like push pause and then call their attorney and say file the protest. In which case, I wanted to get it out there. So
Yeah. Well,
hopefully
and
that.
it sounds to me, I mean, 180 days is 180 days. Every
Mhm,
day that goes by is one more day that you can't go back and protest. So
mhm.
it seems like there's an absolute reason to do this. The minute you hear that this is a possibility to do, it's important to get out there and do that if it applies to you. Should affected parties have faster or stronger avenues for judicial relief?
So the answer is, should they? I mean, so I guess the should part of the question is little bit of a policy question. Right, to the extent that they should or not. Like the Court of International Trade exists for a reason, right? It is the court that houses the experts of the judiciary on questions of trade, international trade, and so the answer is you don't want customs to be the arbiter, right? Because customs is the one collecting the money. That's like having the cop be your judge. You don't want that. Um, and of course, the trade can't be the arbiter because they would be biased. My expectation is that there's a if the Supreme Court concludes that the government went beyond its authority in imposing these duties under IEEPA. My expectation would be that there will be relief granted, and it would be in the form of return and refund of the duties. I could see it possibly. It's possible, I think, that the court could fashion it could create some boundaries around timing, not with respect to filing your suit, but timing in terms of timing in terms of time when you make the claim against customs, or when customs made the charge the duties. But probably not. I mean, I guess I'm sort of thinking I might look. I'll put it this way: duties are statutory, right? Tariffs are statutory. It's not a policy question. If I import something that's subject to 10% duties, customs doesn't have a choice. They charge 10%, right? The question is whether the thing that they're charging is actually within the classification of goods subject to 10%. Right? That's where the gray area is. Maybe my thing doesn't really belong under that code. It belongs under this code. And this code is 5%. Right? That's where you've got sort of gray area. And in the IEPA based duties, a lot of times it's really just about where the goods are coming from, not what they are, right? So Korea is a certain number, and Japan is a number, and Mexico's a number, and China's a number, and they're all different numbers for different reasons. And so my expectation is that the court's going to have less leeway. They're probably going to say, look, if they're no good, they're just no good, and that's it. And you're going to have to figure out how to get them back. I could see them creating some timing and some allowing the government to create some administrative mechanism for how to get that back. But I think they're going to have to refund the money if the Supreme Court says so.
Do you think that SCOTUS could or might treat export bans differently than import bans under IEPA?
Yeah, they do,
You do?
ordinarily, and they do sort of in the real world anyway. Like export, it's historically it's been true that when you import goods, there's duty that's being collected on the way in, and so most of the government's focus and enforcement is inbound, and they don't really look at exports. That's changed because of the risk of doing business with somebody that's on a terrorist watch list, or on a on some in some country of concern, or in some industry of concern, or has been sanctioned or is related to somebody who's been sanctioned. So So now I would say that there's far more enforcement in the export space than there has been in years. Over the last 2 or 3 years, and I think that's going to increase. I think you're going to see a lot more activity in the sanction space. Now, that's not under IEEPA. That's arising under other authorities. I wouldn't expect IEEPA to really impact probably the export side very much.
So at the beginning, you talked about fentanyl, which is an illegal substance, of course, but everything you're talking about, I mean, in terms of tariffs, it's applying in different ways, shapes, or forms to really all imports of all goods. It doesn't matter if it's um, computer chips or furniture or whatever else. Is that correct? Or is
That's correct, and that's why. So I make the analogy. Why I talk about the gray areas associated with a harmonized tariff schedule code. Right, the code itself. My item belongs under this particular classification, and yours is that one. They look the same, but they're not the same thing, and the rules treat them differently. Under IEEPA, because of what the government is doing, is basically saying that no, we don't have an enemy at the door with soldiers, but that's not how countries attack each other anymore. They don't fill up their ships with a bunch of soldiers and put them on the sea and then run them over here and then try to beach their soldiers and then try to take us by land. No, instead they infiltrate, and they infiltrate by things like cartels and gangs and international trade and poisons and coming in and creating problems. This is the asymmetric argument that the government is making. Consequently, the government is penalizing the sponsors of the activity. It's not really going against the trade; it's going against the sponsors of the activity. So it's the former country; it's the other country, the foreign government. Consequently, things coming from China are subject to a particular IEEPA tariff. Um, Now, there can be distinctions within that because there can be exemptions, and that's very often because the government realizes that they need certain things anyway, right? Even though they come from that country. So there's a little picking and choosing going on in there. But it's true. It's far more across the board than and it's, of course, it's not the fentanyl that's being docked. It's all of the other stuff, right? Because the fentanyl is being smuggled anyway. No one's paying duty on fentanyl, and so the fentanyl is the reason for the duty being imposed, and it's being imposed on everything else.
right? And that apply. And there are so many forms of warfare already that people are talking about that we don't even know some of the forms that might be being used. Truthfully,
Yeah, and the purpose of IEEPA, the president's argument is to be able to react to reality, and so the argument is you can't expect to see a government attack you the way that we saw governments attack people during World War I or World War II or Korea or Vietnam or Afghanistan or anything else, any other action, or Iraq or anything else. Instead, we have a completely different type of warfare, and that doesn't make it not an emergency just because it doesn't look like other emergencies. It certainly doesn't make it not international, and so that's sort of the argument. But my feeling is that, and there's a lot of legal arguments to that, and there's policy arguments to that, and I'm not going to get into those. I'm going to let the Supreme Court. That's what the Supreme Court's trying to determine is whether or not they should allow this to go through, and we'll see.
and that's it for today's episode of FDA Imports Cross-Border Compliance. If your company is impacted by IEEPA tariffs and you want help assessing your risk, preserving your options, or responding strategically as this develops, visit FDAImports.com to connect with Ben and his team. If you found this episode helpful, be sure to like, subscribe, and leave a review so you catch the next one.
Thanks so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.